Yes. So the special events, which I think of as rentals to third parties, weddings and the like, have that limitation in there. I don't think there's another express limitation. There's a natural limitation in terms of the amount of parking is limited. I don't think we're planning on having a Woodstock festival there, but that's where if the natural concern of the neighbors, or I think the reasonable concern of the neighbors is noise, the unreasonably loud condition would seem to cover that.
It just seems to me so fundamental, given the distinction between amplification and non-amplification. I mean, if there's a special event with 20 people attending, that's a very different event than one with 200.
Mm-hmm. To me, if there's sound amplification, it's limited. If there's no sound amplification.
No, I know. We're trying to just we're trying to explore ways that we can. So.
Right, but what if, Jeffrey, if they have a kite flying festival and 125 kids show up and they have their parents and their grandparents and whatever, you could have 250 or 300 people.
Yeah, my sense is that those events are very difficult to plan and are probably going to be very few. I think that there's going to be many more events. I don't actually like the word rental. That doesn't seem to me to be, it's use. So this is about use, right? It's not about rental.
Well, rental is...
We don't want to get into your business, and I don't, I want to be careful to say, look, you have to show me that it's a rental, and it starts to get, I think, just much too complicated. To me, this hearing is about what the last hearing was about, which is what's the intensity of the use, and we're really trying to get at that, and I'm still don't fully understand it because of this issue. So I'm interested in the volume of people. I'm not interested in the legal arrangement between the user and the owner. I'm not. I don't think the board should be. It doesn't matter whether you're renting it. It matters whether they're using it by a third party for a non-museum use. And the real question is, how often is that going to occur? And when it does occur, how many people are going to be up there? And I don't have a good sense of that from this conversation. I hear from the neighbors that they want to limit that to 12 per year, 1 per month. And I'm hearing from the applicant, 12 per year, 2 per month, but it's only those events that have sound amplification. I know that's a shortcut. That's a shortcut of doing it, but and I think there's a wide. I know you're saying that there's not much room to go, but I think there's a lot of room in between those two positions. So that's what I'm trying to explore. I'm sorry. Go ahead.
I'll try. I think watching the tape of the last hearing, I think what Ms. Vieira said was, in addition to weddings and things of that sort, which would be a noise concern to the neighbors, they might use it for a gala.
Yeah.
Maybe once a year. I put twice in there just in case. And that I think would be it in terms of sound amplification outdoors. Indoors, I still don't see the concern. But if you're concerned about outdoor fairs and things like that, where there might be a quantity of people outside, there's going to be the opportunity for the public to walk around the property daily, I thought, when it's light out. So there may be people walking around the property. I don't know that they anticipate a great volume, but in terms of having a kite flying fair or an Easter egg hunt, I can't imagine that there's going to be a lot of noise from that, but I also can't imagine they're going to be doing a lot of those each year, because they do take some organization to put together. And I thought she had said the kite flying fair was maybe once a year.
We estimate 3 of those types of events a year, what we would call an outdoor public event. I'm not sure I understand what the definition of fairs and festivals is on both sides, but if I call it a kite festival or a kite fair or a kite gathering, probably 3 of that type of activity per year.
I'm really trying to not do that. I'm really trying to say it's either mission critical, related to the museum, as you've indicated in your application, or it's not.
Well,
and leave it at that.
Those things are mission critical.
And I understand they could be. Yeah, which we may not be talking about those. That's a whole nother issue.
I was just trying to help out on the intensity of use, and that's one use to which the property might be put. I didn't think that Mr. Hills or his clients had an opposition to that sort of related to the museum sort of function.
No, he made that
And I was
clear.
trying to get at special events with things that aren't directly related to museum function, other than fundraising, and that would be having those rental functions. That's why I had rental in there. Anything else would be more in line with central to the mission sort of thing.
The other thing is there will be landscape tours that may attract 20 people, but they'll be going around the entire property and
But those we're not really talking about, because those are related to the
the
mission.
mission.
Yeah.
Well, then I'm really not sure what you're talking about, because the only thing that's not going to be directly related to the mission would be these rentals for weddings and things like that.
This
The
is
kite flying-
exactly why I'm asking why it needs to be 2 per month and 12 per year. It's exactly my question.
Why does there need
Seems
to?
very narrow.
Well, we'd be happy to have more. We limited the number to appease the neighbors.
No. When I say it seems very narrow, there's a limited number of functions that fall into this category once you take away the mission-critical activities, it seems to me. And my question is, how often are we going to have the type of activity that's going to rise to the level of an intensity of use that is, and I'm asking both parties, that would cause concern?
I thought you were excluding from that category things that are kite flying fairs and things like
I
that.
didn't say anything about kite flying. I want mission critical or not mission critical. I don't know about the kites. If the kites are related to the Eustis Estate, then they're related to historic New England's
They are.
mission. But it's not really our business, I think, the Board of Appeals, to dictate what the mission is. We've got an application in front of us. We've got your letter. We know what historic New England will and won't generally do.
Yeah.
And my sense is it could be a couple of years from now where somebody's going to come in front of us and say that there was X event that was not related to historic New England's mission, or it was. I would much rather have it at that than for us to dictate now that a kite festival is or it isn't related to the Eustis Estate.
And I
You know what I
think
mean?
that's, I think we're in agreement that there's some elegance here to leaving things sort of unanswered. And I think that's, I think we all acknowledge that we're not tonight or as part of this proceeding going to try to narrowly define every single possible event that
Right.
could be regulated.
Yeah. That's all.
Fine.
So if you say we're only dealing with activities that are, for just to shortcut it, non-mission critical, because those are the only issues that the neighbors have expressed a concern, and I haven't heard any independent concern of the board, although that might be here. Let's talk about those. And are we really only saying this?
I thought the concern of the neighbors was noise.
Well,
And whether, I thought that was the concern, and that's what I'm trying to deal with. If someone is using that facility for as we said, the facility might be used for a community meeting and partnership as a venue for collaborative programs with other community groups and meetings which serve the community, is that mission critical? I don't know. If we provide a forum for other nonprofits to come in and use our hall, I don't know, but I do know the neighbors are never going to hear it. So that's why I thought noise is a good way to go. And
Right, I
Someone-
mean, I agree, I thought noise was the issue. But I think Attorney Hill, you've represented that your 12 per year, 1 per month is going to include indoor activities.
Right.
And I just think that's pushing it a little too
but only
hard.
non-museum related.
Well, you know, who's going to be the arbiter there of what is and what isn't?
I mean,
burden of fall-
Last week, we had 50 people representing all the nonprofits in Milton, from, Kerry College to the Rotary Club, et cetera. And they loved the invitation, and they loved, being there, et cetera. Is that should be mission critical, in my mind.
The burden will fall on us to prove that it's not. I mean, that's how, I mean, I think that's the standard under the zoning act. And so if we think that, if there was an indoor event that was so obnoxious that we cared so much to come before you to say, this couldn't have happened, this is not mission critical, this is not incidental to their primary use, then you can be assured that we're gonna come forward with a bunch of evidence that proves that. And if we can't prove it, then we lose. And if we want to appeal it, we appeal it, if we really care that much about it. But I think it goes back to the point that we're just laying out some markers here. You know, we're not necessarily going to say every indoor event we're going to jump up and scream about. It's only if there's going to be an indoor event that's probably a wedding or some other similar kind of function with 100 people, and it's noisy, and we're going to say, that counts, that's one of your 12.
Well, what you do then is you discourage the use of this iconic facility to allow other nonprofits to use it for a meeting where there'd be no impact on any of the neighbors. They wouldn't even know it happened. None of them called up complaining that 50 people were there last week. I assure you, if there was a noisy wedding at 11 o'clock at night, you would have gotten a call. And I think that that's appropriate. That's an appropriate consideration for the board. These outdoor speakers, it's going to wake the neighbors up, whatever. Sure, put a limit on that. Do you really want to discourage the use of this facility? I don't think so. I mean, the selectmen were all in favor of it. I quoted the part of the master plan that I did for a reason. It was HNE's intent to use it as a cultural facility offering tours, accommodating scholarly activities, and hosting events. I don't know whether that all falls strictly within an architectural museum, but there's no impact on the neighbors.
So I want to move off. I have a couple more questions. So you would say that having the distinction between mission-related, museum-related, incidental to the primary use and not, isn't really the distinction. It ought to just be on noise.
Or nuisance factors.
I think that's the easiest way to enforce it, and it protects the neighbors the most.
Okay. On the, can I ask?
You have more questions?
I do.
Mr. Mullin, you have the floor.
On the term, why is it not the case that a 5-year term would incent the historic New England to comply so that they could stay up there? I'm not sure I'm following that. And why just the 2 years?
We just think 5 years is a long period of time to go without having a
I don't know
check-in.
that it's a long period of time for a place like historic New England, is my point, you know? Where are they going? Given their level of investment. I just put that out there. I mean, usually a special permit that we grant will say it's subject to reasonable conditions that the board may impose from time to time. There's a fair bit of pressure on special permittees in this town to comply with the permittees because of that. And it's bilateral, you know what I mean? You know, anyone can bring people up. So I've seen it both ways. I've seen that condition, and I've seen a term, and I've seen both. And we just had that situation with Eagle Farm. It just seems like in 2 years we'll be all back here and doing this, having the same. Maybe we won't. I don't know.
Well, I think that, just to put in perspective, what we're talking about here is just simply the commercial special events. We're talking about renting or letting other people use the estate for parties. You know, we're not talking about anything else, and we just think that segment of this should be reviewed in 2 years.
Yeah. Okay.
And if you wait 5 years, then we've got 5 years or 4.5 or 4 years worth of events that we as the neighborhood, we can come in and complain about them, but we don't necessarily have, there isn't a process set in place to potentially amend these conditions.
Well, you could be.
I'm not sure of that.
Yeah, I think you'll find that we'll. Well, I don't want to speak for the board. On another
Well,
question.
you could amend your,
Ask as many questions as you want.
you could amend your own my understanding, and correct me if I'm wrong, you may have your own practices, but under the law, you could amend your own conditions, but we as neighbors couldn't ask you to.
What we see is a neighbor will seek enforcement of special permit by the building inspector. The building inspector will then ask the Board of Appeals to issue a ruling, and we do that fairly
Right, but
often.
they could be in compliance with these conditions, and it could still be a problem. And that's the issue.
And we've decided whether or not it's a problem or not, you know. On the regulation, the DEP regulation, if you're pointing the speaker at the Quinn Estate and you're measuring at 10 decibels at the property line, aren't you pointing the speaker right at the place where you're going to measure the noise? I mean, the closest property line is Quinn's property, you know, and I actually, you know, it's kind of an interesting site, given the size of the site, measuring at the property line is a fair standard, but not if you're pointing the speakers at the property line,
Well-
you know?
Well, hey, look, we're not concerned about the property line at the
No,
Quinn
I know,
Estate,
but that's the
so-
standard in the reg, right? It's gonna be, you're gonna be measuring the noise at the property line, aren't you? The-
But we would have no standing to argue about that, since we don't own the Quinn Estate. So-
No, but we're setting ourselves up to violate the reg that we're laying it. I like the standard in the reg because it's a bright line, and I can see, just based on this hearing, we're gonna have a conversation about what's unreasonable, what's reasonable, and maybe that works in a town like Milton. We don't have a lot of this kind of thing, and this is pretty unique, I have to say. So, but it does sound counterintuitive to point the speakers at Bob Quinn's house, the Attorney General, and then have, you know, he was the Attorney General after all. And then use that to violate the reg. It just, there's got to be a different way to do that, so.
Well, I think you could, in your condition, carve that out as an exception, that since they own the property.
Yeah.
That is not the property line for purposes of this enforcement.
We own the property, we bought it for defensive purposes, we do not plan on retaining it. And it will be, we expect that it will be ultimately sold, but with restrictions on it.
Yeah, I think for this board to say the speakers shall be pointed at that house, when we could point it towards Canton Avenue, and maybe there would be no unreasonable noise impacting anyone, and that property line is so far away, I don't see why the board should get that into that level, what I think is micromanagement. There's a reason why you haven't had these sorts of disputes in this town or in most other towns, because people try to work them out.
I don't have any further questions. Thank you.
Mr. Lundblom?
No.
Okay, let me, the attorneys have had their say. Let me just see if there's anybody out there, a member of the public who wants to be heard. Just please indicate. Yes, sir. You're going to have to come up here, Mr. Shillingford. You can't, we can't hear you back here.
My name is John Shillingford, 1386 Canton Avenue. I'm the last man up Chestnut Run. I heard you mention earlier that people were principally considering the noise element, which is a feasible argument. I'd like you to use your imagination to envision what might happen here. These people have, New England Historic has said that one of the assets of the property is to have people, principally in the daytime, I would guess, look around the estate, right? It's a magnificent estate. They speak of 80 acres. Only about 30, I would guess off the top of my head, about 30 acres are pertinent to any people that might want to wander around. Up the farm and then back of my place is all relatively rough country. I don't think many people are going to go up there. However, during the daytime, people might be encouraged to look around the property, which is lovely. One of the assets of the property which they might look at would be the pond. Now, do you have I don't know, most people have a map here. Can anybody know where the pond might be there on the map?
Mm-hmm.
Look like there are several bodies of water back
I
there.
think it's so much.
If you look up Chestnut Run,
Yep,
the orchard, which has been discussed, is on your right as you go up.
yes, sir.
As you go up, and then there's a field to your left, and there's a pond there.
Yes, there is.
Yep, and there's also a semi-formal garden which Libby Eustace has put considerable effort into, which makes the site more attractive. There's what I think is an ice house down there also, an old stone ice house. Now, if people should walk around the property, that would be an appealing place for them to go. Now, that would presuppose that they would walk past the orchard, which is a lovely spot in itself, and the rhododendron planting on the hill right next to the orchard, and then they cross Chestnuts Road, Chestnuts Run, if you will, and they go down the field to the pond and wander around down there, right? Now we have a significant portion of the guests possibly going back and forth across Chestnut's Run. Now, of that, there would probably be a few who would be curious to go up Chestnut's Run and see all the fortunate people that live up on Chestnut Run. So now, what we're talking about here is what has been a historically tranquil scene enjoyed by the neighbors, which all of a sudden we're going to have a relatively uncontrolled group of people wandering around. Now, is my point made?
I'm not sure what your point is, because the way you're describing this, they would be on property of HNE. They're invitees of the estate, so presumably they could pass and repass on the road. They wouldn't have the legal right to go off of the
I'm not
road
disputing
and
their
go
right-
onto your property.
I'm not disputing their right to do it, right? But what is involved here is not just the noise of a party that's over on the other side of the hill. What's involved here is people at these events wandering around across Chestnut's Run, and maybe a few of them up Chestnut's Run to see who lives up there and so forth, right? Contingent of what this impacts is the number of events that are had and the number of people that are at those events. Now, if this is a regular happening every other weekend in the summertime, it's a nuisance, or it could be a nuisance.
Well, you could, I don't want to be argumentative, Mr. Shillingford, but you could reverse that argument and say that people who are coming up Chestnut's Run to visit your property are causing noise that somehow is affecting the estate. This is the estate's property. Am I wrong? Does the HNE own Chestnut's Run?
Question. No, I don't dispute
They own the
I don't
fee.
dispute the right at all.
Okay, all right.
What's pertinent here is how often is these events going to happen? I mean, it's somewhat of an inconvenience for us to put up with that, if I may use the word put up with it, right? I'm not disputing their right to do it, right? But if this is going to be a constant event with people wandering around, you can imagine that the peace is disturbed.
Okay,
Okay?
sure, thank you. Is anybody else who'd like to be heard? Okay, the record indicates there's no such person. Oh, yes, sir, come on, come right up here.
Hi, I'm John Seidman. We live next to the Suffolk Resolve House.
Sure, I think you spoke
We
at
spoke
the
last
last,
time, yep.
what's your address, sir?
1350 Canton Ave.
Good, welcome back to the Board of Appeals.
So I just wanted to clarify one point that I think was raised here, or at least clarify, at least in my mind. My understanding, your argument, you made the argument that this fundraising might be necessary, money-making might be necessary for the activity of this museum, for this estate. I just want to remind, or just ask, so my understanding is Historic New England has 36 sites, and of those 36, I believe 7 of them have events of the type we're talking about. So it seems that 29 can get along without this activity.
Oh, what do you base that on? I don't think we've had any evidence to that effect, at least I don't remember it.
I base it on what, if you go to the Historic New England site and ask and look to where you can make, and we can ask, if you, please correct me if I'm wrong, but my understanding is that you can do, that 29 of them don't have weddings and 7 do. So it's not every site that requires this activity. So I just want to clarify that we shouldn't be thinking that this is a requirement of these museums.
Do you want to comment on that, Mr. Lipkind? Is that true or not true?
I
or-
don't know, I just know that this was a pretty expensive site, and it takes money to buy such a site.
The other
Okay.
thing is some of the other sites are single buildings on a small lot, which would not be conducive at all to having a function, and you would have no functions there.
Anybody else would like to be heard? Yes, sir.
Hi, my name is Peter Jeffries. I grew up next to the Eustis Estate, and I live at 67 Vos Hill Road currently. A couple of things, and I wasn't at the last meeting, so I don't know if Curry College and the noise from Curry College that is evident in that neighborhood when they are doing a function, just to give everyone...
That did not come up at the last hearing.
When they're doing something at Curry College, and if you look at the site plan, you can see where Curry College is, the main driveway shows, and it's across Canton Ave and Blue Hill Ave, so it's quite a ways away, and the sound does carry, so I just wanted to point that out. So when there is a function at the Eustis House, as was pointed out before, the sound will travel. On page 5 of the letter from Mr. Lipkin, there was a reference to the Wallaston Golf Club, the Hoosick Club, and the American Legion Hall, and the fact that they do quite a number of weddings.
Wedding reception.
Wedding receptions there. And I'd like to point out that they, to my best of my knowledge, they've been doing those for years. And the neighbors have made a choice to live there and to be acceptance of that activity. I spoke to a neighbor of the Milton Hoosick Club who's lived there 5 or 6 years. She made a choice. She was fully aware of what was going on when she purchased the house, made a choice to accept it. In this case, with Historic New England, this is a new use. And I think it is incumbent on the board to take that into account and go slowly with the permitting process and the number of events so that the neighbors can get a feel for how it will be. And, you know, I fully support Historic New England buying the property and using it, and I understand their needs. But, and I think it's great, and it's much better than having house lots there, though I should add that 35 acres of that does have a conservation restriction on it. But I think that going slowly in terms of the number of events, so everybody can get a feel for how it all works out, and then in 2 years, or maybe 2 years after the museum opens, would be appropriate for a review period, a look-back period. So thank you.
Great, thanks, Mr. Jeffries.
Mr. Leonard?
Yes, Mr. Lipkin.
Can I address something that Mr. Jeffrey said?
Of course you can.
Just with regard to the 2-year period, planning events, especially a wedding, can take, sometimes they're planned more than a year in advance. So if a 2-year limit is imposed upon us now, in reality, we're not going to be able to use the space for that function.
Thank you. Anybody else who'd like to be heard? Okay. So there is nobody else who wishes to be heard. Counsel, are you all set? Have you said your piece?
I'm all set.
Great. Okay, so we'll call an end to the evidence portion of the hearing. And yes, it's our obligation under the open meeting law. It's our obligation to decide this in open session and discuss it in open session, and we intend to do that here and now. Let me start out just by saying that how much the board appreciates the hard work of the lawyers in this particular case. I thought that Mr. Sheffield always is enormously thorough, has presented a wonderful application. Mr. Lipkin, this is one of the areas of his expertise. We appreciate his comments and his hard work. Mr. Hill has done a wonderful job at both hearings and has provided the board with a compelling letter with his view of this. And I just think it's a credit to everyone that everyone here acknowledges that this particular HNE, some refer to it as a gem, as Mr. Hill does, historic. It's a significant, the selectmen have told us, and the Milton Historic Society have talked about how significant it is and how important it is to have HNE here and to have them successful. So I think really everyone here has acted in good faith, representing different interests, obviously. And I just want to tell all of the attorneys present that they did a terrific job on behalf of their clients. Their clients can ask for no more. I know good lawyering when I see it, and I have seen it here. I'd also like to thank the neighbors for their participation in these hearings, more at the last hearing than this one. Always amazes me, and I think it's a credit to the town, but it's also a credit to the neighbors, that people can discuss issues that are as personal as the use of real estate that's next to their home, that's going to be a different use than previously, how they can discuss the issues objectively, in good faith, and in good spirit. And I saw that here. It's remarkable. Some of the variance hearings we have can be somewhat difficult, and everyone here has, I think, comported themselves with dignity and with good faith, because everyone wants this project to work. So I think everyone's worked hard. The hearings have gone well. And there's a lot of agreement here when you look at the basic issues. We're differing in a couple of substantial areas, but there's a lot of it that's nuanced that the board is called upon to decide, and that's why we get appointed to do these things. So I have said my piece on all of the preliminaries. Mr. Mullen, do you want to be heard? If you don't want to be heard, that's fine as well.
No, so this is really tricky. Is there no special permit in place now at all?
Correct.
Nothing, yes.
There is conservation permits and, other types of permits.
How long, I know that the property was purchased in, what, 2012?
2012, and the residents, Libby, the Eustaces, were allowed to live there for 2 years after the transfer of ownership.
Yeah.
And during that time, it was residential, and it was only after that they left that we applied and obtained charitable status from the Board of Assessors. And of course, that has to also be ratified by the Board of Appeals.
Yeah. So the reason I ask is I was struggling with this issue of the distinction between museum use and non-museum use, and actually the Board of Appeals jurisdiction over the matter. But it seems to me that we've got jurisdiction over the entirety of the use, given the fact that the charitable nature of the use is subject to the issuance of the special permit.
Correct.
And that makes this very timely, given Commissioner Prondak's letter. So let me just, I think this is a matter that calls for a bit of a conversation, if that's okay, Mr. Chairman.
With whom are you going to
No,
converse?
with the board.
Oh, that's fine, sure.
It seems to me.
Well, look, I agree with you, Jeffrey. I think there are nuances here that need to be fleshed out, and nobody is. I asked Mr. Mullen to speak first, and I'm glad he took me up on my offer, because many times in these hearings where you're running the hearing, you can be perceived as taking over too much of a role. So I tend to like to run the meetings, ask questions, but have the other board members take the lead. But in doing that here, I asked Mr. Mullen to speak, not that he was going to dictate a decision to us, but that he was going to talk about his views of the positions of the parties, so that the other board members, including myself, could discuss them and come to some consensus. So why don't you proceed? We're delighted to have a conversation with you anytime.
So I've been sitting on this Eagle Farm case for 15 years, right, Steve? And we've had many hearings on Eagle Farm, and that's a much beloved, in the main, facility in the town, and people appreciate having it, I think. It's on a busy street, but there have been a lot of issues up there. I think Mr. Jeffries' point is well taken about trying to go slow and trying to establish a track record. And that's been my experience, and perhaps Steve's as well, in observing the things that have happened at Eagle Farms over a long period of time, certainly longer than I've been on this board, going back to the 1960s, as you know, Bob. So that's one thing that's on my mind. I don't like varying the board from the typical standard of being able to modify the special permit from time to time and subject this to the enforcement of the building inspector, notwithstanding the concerns that were expressed about perhaps that being risky. It seems to me that's on both sides, and that's very appropriate for something that we're just starting out with. And I also think a term is okay. I might not have said that if the applicant didn't agree to it. I'll say that. But I think in this case the term makes sense. But 2 years I think is a little short. Particularly given the track record that has been established by Historic New England and the fact that the special permit is subject to continual enforcement by the building inspector and by a hearing of the Board of Appeals. And we don't lack for sitting in this room and hearing these cases. We've certainly done it enough. So that's the third thought. The fourth thought is I like the DEP regulation. I don't like to enforce the DEP regulation, but I like the standard in the DEP regulation. And I think measuring the decibels and getting away from something that's reasonable or unreasonable, particularly after the fact, is going to be really difficult. Not getting away from it, but trying to determine whether the noise was reasonable or unreasonable is difficult. But adhering to the standard in the DEP regulation, I do think having something where the applicant is obligated to take steps to minimize the noise on the neighbors is reasonable, without dictating the degrees to which the speakers need to be facing. You know, again, Mr. Jeffries' point about, I'm actually pretty familiar with the layout here and the hill. And I'm not sure I would have predicted that the Curry College noise, although it's directly across from the hill, from the museum, as the crow flies, it seems to me, if you walk through that property, you'd be right at the circle off of Blue Hill Avenue. I would think it would be more typical that the noise would flow downhill rather than uphill, but the fact that it flows uphill is interesting to me, and really just reinforces the fact that we should have some type of standard, and because we don't know anything about noise, DEP does, that seems to me to be reasonable. And I'm not saying that the Board of Appeals wants to get in the noise business, but it seems to me that we could have a conversation about whether or not the noise was violated and rely on the Commonwealth standard. In terms of the related or not related to the museum, I'd like to try to keep that simple if we could. And what I'm hung up on is the non-museum number of events, limiting those while at the same time not drawing a distinction between museum events that emit sound and those that don't. So I'd like to maybe have a conversation about those, about that issue. On the rental, I already commented on the rental. You can tell by my comments, I really don't want to get into, and I don't think the town has any business getting into Historic New England's business. And this isn't about rentals, it's about uses. And I'd prefer to, and I'd encourage the board to stick to that standard. I like the offer of a premium membership because I can see this being a fairly popular place. And I read Kathy Heater's letter, and I thought that it was very well done, and I can see her concern along with Mr. Schillingford's concerns and the concerns expressed by the Seidmans, not at this hearing, but at the earlier hearing. So those, I think, that really is the extent of my comments at this point, John.
Okay. Mr. Lundborn.
Thank you, Mr. Chairman. Jeffrey, could you just touch again on your thoughts on, in terms of use, as opposed to defining what is and isn't a museum function? I wanted to just hear that again.
I just thought that the number of events, I thought what I heard from the neighbors was that the number of events would be those not related to the activities that were central to the museum. And I would say that we could say that as expressed in the application, which I think would include your letter.
Yes, that
went-
makes sense.
Alan, you went through that in your letter.
Yes, I did.
Yeah. And they said 12, one per month. The applicant said
12, 2 per month.
12
Up to two.
events at which sound would be amplified, 2 per month,
Yes.
whether it be related to the museum or not. That's what I heard.
Correct.
Well, other than the members, the preferred members would be the ones having the wedding.
Well,
So that's somehow related to the museum.
no, that's a different condition. That condition would be in order to use it for a non-museum event, you'd have to be a member of a premium membership associated with the applicant.
Yes.
But that's a different condition, right? This condition
I
about,
think they're related. But
well, they are related in the sense that that's the user class. In order to be a user, this is confusing, and I'm making it more confusing. Part of the confusion is I think we've got a little bit of a different explanation of and, we need a matrix, and we can't draw one because we don't have time. But the applicant is saying that it's all events, any event that's held at the museum, whether it be museum-related or unrelated to the museum. But they have to be amplified by sound and held outdoors.
that's the trigger.
Isn't that right? Yes.
I didn't know if you were allowed to participate.
Well, no, I
Should
am
close the
pleased
hearing.
because
If
it's
you look-
confusing to me.
I understand.
Yeah.
Maybe I didn't do a good job.
No, you did great.
But I'm looking at my compromise conditions, and we have a numerical limit on outdoor sound amplification, what I call rental events to third parties of 12 per year, two per month max. And then I have under museum operations, category B, those wouldn't be considered a special event, subject to numerical limit, but if Historic New England is going to use that property and have an event with sound amplification, it's scheduled to the same time, 10 a.m. to 10 p.m., that sort of thing. And same sound, can't be unreasonably loud.
Right.
I'm just looking at page 1 of my compromise conditions.
Yeah.
I just don't want
Okay,
to...
so here's the issue, right? So one of the problems is your conditions don't really line up. They don't mirror each other. It doesn't seem like the neighbors have responded to the second condition that you expressed, and that's something that I've been struggling with. So I'm sorry, Steve, maybe it didn't help you, but I was trying to make it simpler by speaking to this only related to the museum. Maybe that's not possible.
Yeah, we've got to find a way, because my fear is we're going to get caught up in this, trying to define
Yeah.
what is and isn't museum-related. But my overall notion and feeling here, the last 2 meetings, is that the neighbors are supportive. And I'm not so sure, and Attorney Hill, you've done a tremendous job, but I'm not getting the sense that the neighbors are perhaps looking for these clear, bright line definitions between what is and isn't related. Their concern is noise. the concern is intensity of use. So I'm still trying to, in my mind, get an understanding of which way we can go with respect to which event is. I think we sort of need to get away from trying to define which events are museum-related and which aren't, because you just get stuck. In the overall, the best thing that I did is I spent some time up in the estate this weekend.
Great.
Drove around, walked around, and really got a sense. Hopefully, I didn't trespass on anybody's property.
Not at all.
May have, but I took some time, and I was really struck, obviously, with the size and the scope and the beauty of the estate. My sense in terms of sound, for example, and these outdoor events, and the layout and the topography and the way, to me, the affected abutters seem to fall down a slope and they're to the front of the building, and the idea here is to have these events to the rear of the building. And you've got significant trees, historic, well-developed, very large trees in that sort of natural buffer area to the front of the building. That's just my observation. And I think Attorney Hill said that in his experience in talking with his sound experts, that orientation of speakers is one of the best ways to alleviate noise issues. I don't think we get into discussing the size, per se, of this tent that's contemplated. May be helpful to know that. We didn't discuss, that I can recall, how many speakers are we talking about here? That could be something that, if we thought about and addressed, we could get feedback. It may help us to sort through the sound issue.
We did we did say we'd limit the size of it to 200 people, which also suggests an approximate size of the tent. I mean,
Right. But we could perhaps think about a condition related to the number of speakers. I mean, we've been stuck in events, all of us, I think, where we've been trapped in a room and it's just incredibly loud and we're not having a good time. As to the 200-foot setback off Chestnut, in walking the property, in hearing the testimony, I don't think that is something, just in my view here, that is necessary. I just don't see it as being necessary for the applicant to limit guests to within 200 foot of Chestnut, especially as we've discussed. Historic New England owns the land beyond Chestnut, and I just think it's a significant area of buffer that would address any of these issues. As to the term, I agree with Jeffrey. I think 2 years is too short of a time. It's not helpful to the function of the museum. I think it would be very detrimental if they had to come back here, especially in light of what they're trying to do with scheduling functions and so forth. I think 5 years is, obviously with the ability, notice to abutters, the ability to come in and be heard. And that I think leaves us with the issue we were stuck on last time, is the frequency of the use, the intensity, the nature, the number. But just in talking about what has been presented, I think that Attorney Hill's description of non-museum related events is a bit too expansive, and we run into that, what was that kite flying festival related or not related? And when he includes 12 per year, 1 per month, to include both indoor and outdoor, I just think it really limits the overall function here of the museum. I just, somewhere, somehow, we've got to find a middle road, because I think Attorney Lipkin's presentation with respect to no limits on fundraising galas, it sort of just leaves it a bit too open, and I think it raises legitimate concerns with the abutters, so we've got to get somewhere on those issues.
Well, my view of these things are somewhat similar to my colleagues. I look at it a little differently in the sense that I think we should be talking more about the special permit process. We have a lot of experience with special permits in the town of Milton, dealing with much more congested spaces and much more potentially adverse conditions on the neighbors than this particular property presents. And the problem we're facing here is that we have a charitable organization here that has been labeled a gem. Steve O'Donnell from the Milton Historical Society said they have a fabulous reputation. There's no evidence that the 37 or 38 other facilities that this organization owns and successfully operates of any abuses or improper management or failure to take into account neighbors' feelings and neighbors' rights. And so we're looking at these events in a vacuum because the applicant has not started and won't start for another year to operate this particular facility. But we do know that it's a successful organization. They're investing $11 million plus in this particular facility. They have been, in my view, solicitous of the neighbors in trying to reach an accord on very difficult issues because we're dealing in a vacuum. So they have acted in good faith. The neighbors have acted in good faith here. And so I think, as Mr. O'Donnell said, that, and Mr. Jeffrey said, we should act cautiously here. And we shouldn't treat this charitable organization, which is intending to do great things on this property, and to benefit the town, not just in the preservation of open space, but to have a magnificent museum there. We shouldn't put this organization, in my view, on probation. They've done nothing wrong. In fact, they've done everything right from what I see. And they've exhibited goodwill in an attempt to deal with the neighbors. The beauty of the special permit process is that it's always variable. It can change based upon conditions, on performance, on whether there is a nuisance taking place. And we're able to deal with those events on a factual basis and not on a conceptual basis that we're trying to do here now. And that's the problem you face. If you're dealing conceptually, how do you get a definition that's not too restrictive and not too general, but something that allows people to have the flexibility to operate the facility and not think that they're on probation or anything like that, but yet to have cooperation between all of the parties. I look at history here, and you know, the history, it's a different set of circumstances, I'll admit to that, but we have the Milton Marketplace right in East Milton Center, which is a commercial use in a residential zone, an intensely residential zone. Right over the fence, there are backyards of properties. And since they're in a residential zone, anytime they want to make a change to that facility, they come before the Board of Appeals to amend their special permit. It's a wonderful organization. It's wonderful for the town to have that type of upscale marketplace. It's beautifully managed. It's been operating, in my mind, for 15 years or more. We haven't had one complaint, not one complaint from a neighbor on Milton Marketplace. We have Steel and Rye, the new trendy restaurant down in the village. Big parking lot, their hours are somewhat long, a very busy place. It's an exciting place for the town of Milton. It's lively, it's young. They exist by special permits. They've been in operation for 2 or 3 years. We haven't had one complaint. And we have Abbey Park, which is older than Steel and Rye, which is right down in East Milton Square. They operate under a special permit. They have a parking arrangement that is difficult, but they work with it. They work with the neighbors. We haven't had one complaint that Abbey Park has ever violated their special permit. And what I learned from that is that properties and businesses that are well managed by people of goodwill who want to work with the neighbors, they work out their problems and differences. They don't have to come back to the Board of Appeals. Could they? Yes, they could.
Like Eagle Farm.
Well, Eagle Farm is different, and that's and also we have Thayer Nursery. We have a lot of hearings on Thayer Nursery involving the various statutes and special, but I'm not going to go there. I'm suggesting that, in my view, and I'm not a seer, I'm not trying to predict the future, but with the track record of this particular organization, and with knowing the good intentions of the neighbors who support this particular use, I think this is going to be a win-win situation for both of them. Maybe there'll be some friction here or there. Maybe some definitions will have to be put into place. But I think that it's such a wonderful benefit from the town. If you read the selectman's letter and you read Mr. O'Donnell's letter, they're a wonderful benefit to the town. And it's maintaining open space up there, and it's putting the open space to a terrific use. I think this is going to be the same situation as the Milton Marketplace. I think you're never going to be back before the board, but you have the opportunity to come back before the board. And so with that in mind, I tend to think that we should proceed slowly, and we should proceed in a manner that is not unduly restrictive, and that is not unduly particular, dealing with the management of a philanthropic property like this one. This Board of Appeals knows nothing about running philanthropic organizations. I don't know how they get financed. I don't know what they need to do. I have no history in it. We'd be the last people you'd want to come before to get a lot of restrictions as to how you should operate your property. You should be telling us, and you have told us how you want to operate the property. So my view is that it's a terrible mistake for this board to get involved in minutiae here and to start to talk about, well, the tent can't be more than 300 feet long and 50 feet wide, and you can't have more than 3 speakers, and maybe and you can't have if you have a band, there can only be 4 people, and that's craziness. We can't be getting involved in that type of thing. It doesn't benefit the neighbors. It's going to cause confusion, and it's totally unnecessary. It's micromanaging with unduly specific regulations, a charitable use and a philanthropic organization that has an impeccable reputation. It makes no sense to me unless they don't act reasonably towards their neighbors. And everything I see, they have acted reasonably. And I really think both parties here, Mr. Hill, Mr. Lipkin, you're really very close, except on 2 or 3 issues. So, and since we can deal with those issues here and now, but we can modify them if we deal with them incorrectly, we're in a situation that nobody's going to lose here, because the board, even though this is a quasi-Dover amendment case, Mr. Hill is absolutely right. If he's running weddings even though they benefit the charity, I'm not quite sure that gets you under the fence of the Dover amendment. But on the other hand, I think it's really important that there be this give and take. And I think you have the give and take, and the question is, how do you make your definitions to start out on this process? My view of it in terms of the events, I think it's an impossible task to start to figure out what's museum-related, what is mission critical, and this is all psychobabble in my mind. Nobody knows what it means. Maybe the regulators in Washington, D.C. would know what it means. I don't. And I think that's really a slippery slope to go down. It seems to me that the applicant has indicated that it wants museum and historic related uses as its principal activities, but for the weddings. And in my mind, this is a spectacular place to have a wedding. I think that you're going to find a lot of people not only attending the wedding, but touring the mansion as part of the wedding. I know where the photographs of the wedding are going to be taken. They're not going to be taken in the tent. They're going to be taken right up at this beautiful building and on the inside of the building and in front of the building, and all of the guests will want their photographs taken there too. It's a spectacular location, but the applicant, in my mind, has tried to reasonably suggest that they'll limit the number of weddings to 12. The neighbors agree to 12, and I think that's a wonderful concession. And the question is it one wedding a month, or is it during the summertime, can the applicant have 2 weddings? And I think the problem with the weddings is noise, which is the second part of this. And if the noise is too much, then certainly the neighbors need to be protected. So I don't think at the initial stages of this that I would insist that there be 1 wedding a month. And I would certainly give the applicant the benefit of the doubt and the benefit of operating the property, as long as it's operating the property in a way that is not offensive to the neighbors. So if there were 2 quiet weddings a month, and it fosters this charitable use, I would tend to allow that. I think I disagree with Mr. Mullen adopting the DEP regulations as part of the board's decision. I don't think that's really good at all, because then you have the Board of Appeals involved with these regulations, which frankly I don't understand. It's like traffic engineering. But that doesn't mean that if the neighbors believe that the noise emanating from a wedding is too loud or unreasonably loud or noisy, or whatever the expression that Attorney Lipkind uses, that they can't do their own testing to try to determine precisely and in a scientific way what the decibel level is. And you could mention that. You could come to the board. You could go to the building inspector. My guess is that there'll be policemen present at these weddings, at least in the initial stages. It certainly would be a good idea. And, I think that's the way most weddings are set. So I don't think it's prudent for the Board of Appeals to adopt the DEP regulations as part of this. But certainly we can take judicial notice of them or administrative notice of them in the 10 decibel standards. I don't think we have to adopt it as part of the decision to do that. And I think with respect to the orientation of the speakers, Mr. Attorney Hill says that that's critical. The applicant says, well, we're going to aim the speakers towards the gatehouse. Well, I don't know whether that's going to work or not, but my suggestion is give them a shot at doing that. I frankly don't understand why it couldn't be, the speakers couldn't be directed away from the gatehouse and towards the west. But you know, that's something that can be worked out on trial and error basis. I can't imagine that if the neighbors were complaining that the orientation of the speakers was causing them discomfort or not allowing them to peaceably enjoy their residences, I can't imagine that the people running these events wouldn't turn the speakers and see if that cured the issue. I do think that a 2-year look-back term is inappropriate. I understand why Mr. Hill makes that argument. It's an argument that he's making for the benefits of his client, but I think practically it is too short, and I actually think that the 5-year term that Mr. Mullen and Mr. Lundbohm suggested is reasonable. And what Mr. Lipkind has done in his proposal is he has adopted the standard of renewal as set forth in the Hop Garden case. It seems to me like this is a very sensible way to go because it allows, even though it's 5 years, it to be automatically renewed, but there's a newspaper publication, and if somebody objects to it, then there's a public hearing, and you can introduce evidence on any of these issues. It's a way that if there are no issues and no violations of the conditions that we establish, you're not requiring the applicant to come before the Board of Appeals, so what are you coming before us for if there's nobody objecting to it? So I think the condition set forth in Mr. Lipkin's proposal, which is the actual condition that the appeals court, in a rescript opinion, affirmed, I think is the reasonable way to go. So my view of